Palsgraf versus Long Island Railroad. Court. This case was decided by the New York Court of Appeals in 1928. Issue. The primary issue the court considered was whether a party is liable for damages when the act that caused the injury did not create any reasonable apprehension that injuries would occur. Facts. The facts of the case were as follows. The plaintiff, or appellee, was Palsgraf, a man standing on a Long Island Railroad platform. The defendant, or appellant, was the Long Island Railroad, a train company in New York. Two people were rushing to catch a train. One jumped on as it was moving, while the other, who was carrying a package, looked as if he was going to fall. Two Long Island Railroad employees tried to help him, causing his package to fall. Unfortunately, the package contained fireworks, and it exploded, causing injury to Palsgraf, the other passenger standing on the platform. Palsgraf sued the Long Island Railroad, arguing that it was the employee's negligent conduct that caused the fireworks to explode and subsequently his injury. The Long Island Railroad argued that, because there was no reason for the employees to suspect that a person would be carrying explosive, it was not their fault that the package exploded and injured Palsgraf, so they should not be liable for the damages. Two lower courts in the appellate division ruled in favor of Palsgraf. The employees were found to be careless and negligent in the way they handled the passenger and the package. So, the Long Island Railroad appealed to the New York Court of Appeals. Again, the issue being considered here is if a party is liable for damages when the act that caused the damages did not create a reasonable apprehension that damage would occur. Analysis. The New York Court of Appeals ultimately held that it is not. In reaching its holding, the court reasoned that the Long Island Railroad employees did not know the package was explosive and had no reason to suspect it was. Moreover, the only measure of care that can be expected to be taken against accidents and negligence must be the amount a reasonable person would take considering the circumstances and available knowledge. Additionally, because there is not reason to suspect that the package was dangerous, there is no reasonable apprehension that the act would create a risk of harm, so the act was not negligent. Because of this, the New York Court of Appeals held that there is no reasonable apprehension that damages would occur to Palsgraf, and because of this, the Long Island Railroad was not liable for his injuries. Rule to remember. The rule to remember here is if injuries occur due to an action or conduct, negligent or otherwise, a party is only liable for them if the party could have reasonably foreseen that the action would injure the victim. A party is not liable for injuries that occur if there is no way to reasonably foresee that injury would occur from a particular action.